Let's head to South Africa, where former President Jacob Zuma is again fighting to remain out of jail. The Democratic Alliance, the Helen Suzman Foundation, and AfriForum applied to the Supreme Court of Appeal to have Zuma's medical parole overturned. The three organizations want Zuma returned to jail after the former Correctional Services Commissioner approved his parole. Zuma's lawyers argued that Fraser had every right to approve Zuma's parole. Joining me now to look at the details of the case is News Central's correspondent Dianne Hawker. Dianne, good to see you, and thanks for your time as always. The former president has spent much time recently fighting for his freedom. So what is the origin of the case for Africans to understand?
Yes, absolutely. I think it might be a bit confusing for those of your viewers who don't live in South Africa. We've become quite accustomed to seeing all these different, cases involving the former president. This matter is related to the Constitutional Court's finding that the former president should be jailed for refusing to appear before the Zondo Commission. Now, you'll recall that last year, the former president, Jacob Zuma, was indeed arrested for that defiance of a court order, and he spent, a few weeks in jail. He then applied for medical parole and was actually granted medical parole. These organizations, however, have been questioning the process that was followed in granting that medical parole. Their concern is that the Correctional Services Commissioner, Arthur Fraser, actually overturned a prior decision by the Medical Parole Board, which consists of doctors. And they've argued in court that the parole board is actually the proper body to make that decision, that the Correctional Services Commissioner should actually abide by what that board decision is. So that's where we find ourselves at the moment. Your viewers will also remember that the other case is still ongoing in Pietermaritzburg, and that relates to corruption charges against the former president. So the former president's lawyers have been quite active in the various courts trying to deal with the various matters with which he is currently involved.
So Dianne, not one, not two, the organizations that have taken him to court all have different interests, isn't it? So what are their backgrounds?
Well, I think it's interesting to note, Suleiman, that, for example, the Democratic Alliance is the official opposition party in South Africa, and they are amongst those who have brought this court case. You also have AfriForum and the Helen Suzman Foundation, who stand ideologically at different sides of the political spectrum. They are civil society organizations, but AfriForum is mainly sort of involved with issues that relate to the Afrikaans community. They often, lobby in relation to that, whereas the Helen Suzman Foundation is more on the liberal side of the spectrum. But all three of these organizations have actually found each other with a common purpose of arguing that the former president should not have been allowed out on medical parole. And in fact, the Helen Suzman Foundation goes further to say that even though Zuma's parole would be concluded, or rather his 15-month sentence would be concluded in October, that the court should not count this time that he's been out of jail. And in fact, if he is returned to jail, basically, pick up at the months that he should have been in jail. So he's essentially saying that he should stay in jail for much time longer.
And the former Correctional Service Commissioner's decision to release Zuma is now in the spotlight. Let us in on the arguments on this.
Absolutely. So, the former commissioner, Arthur Fraser, is very central to this particular story in that, there are questions about why he made this decision. Some of your viewers might also remember Arthur Fraser's name in connection with the charge laid against President Ramaphosa over the Phala farm. So quite an interesting political figure in South Africa. He is a former head of state security in the Zuma administration and was later moved to correctional services. And now we find him as one of his last acts in that position as the man who signed off on that medical parole. The arguments in court are questioning whether he had, the appropriate motivations and whether he took into consideration the reports that were submitted by the medical parole board. One of the things that was brought up in court, for example, is that the medical parole board looked at various medical reports and that it concluded that even though the former president, Jacob Zuma, did have a number of comorbidities, he was stable and did not qualify for medical parole. Arthur Fraser then, who was commissioner at the time, overturned that decision and actually granted the medical parole. And a lot of the legal argument went around whether his position is actually empowered to overturn such a decision if the medical parole board is the body that is meant to make that decision.
And before I let you go, what's Zuma's defense to these calls for him to return to jail?
Well, we saw his lawyer, Dianne Hawker, arguing quite strongly in court today that the former president is suffering from what he's referred to as a terminal illness. Now, that illness hasn't been declared, publicly. However, it's been called a terminal illness. And as a result of that, the medical parole legislation does, in fact, allow for someone who is suffering from a terminal illness and presumably doesn't have much time left to live, would be allowed to actually apply for medical parole. However, this legislation has been used in a very varying way in South Africa, which is perhaps also one of the problems, Lemon, is that it isn't consistent in its application, in how people, are able to be granted, especially those who are seen to have some sort of political sort of connections, have been granted medical parole when others say that they've been denied in the past and they actually do have serious medical conditions. Dianne Hawker also saying that, the former president needs 24-hour care and that he's not able to get that care at the Correctional Services facility. He argued that he'd be able to get that 24-hour care at the Nkandla residence, and saying that that was also part of the motivation that was made in this case. Now, the judgment has been reserved in this matter. The Supreme Court of Appeal will make a notification when there will be judgment. And this is a court that sits with 5 judges at a time ordinarily. So it will take a little bit of time for them all to confer and get to a final outcome on this one.
Dianne Hawker, many thanks for your time as always.
Thank you.
Gabriel Krause, who's the head Institute of Race Relations Campaigns, was in court today. He joins me now on the news to give a legal perspective of today's proceedings. Good to see you, Gabriel, and thanks for your time. You were in court today. Tell us, if you will, from the legal perspective, how the proceedings went.
It was a long day. The deliberations started at about 9 a.m. and finished almost at 7 p.m., which for court is unusually long. Really, I think there were 2 questions that the court was asked to answer from a sort of technical legal perspective. The first question was between the commissioner, the prison boss, the commissioner of correctional services, and the medical parole board, which is made up of 10 doctors, which of those 2 gets the real say in whether a prisoner deserves to get medical parole? On the side of the Democratic Alliance, the Helen Suzman Foundation, and AfriForum, 2 non-profit organizations and 1 political party in opposition, they were all saying that the medical experts should get the real decisive say in whether someone deserves medical parole or not on the basis of whether they have a terminal illness or not. On the other side, on the Zuma party side, they said not really. The prison boss should get the final say, and he should be able to look at private doctors, independent reports, and kind of weigh up between them. The decisive factor, in my opinion, the factor that were the justices, the 5 justices on the court most often talked about and drew questions out about, was a regulation which specifically says that the prison boss can only begin to consider giving a prisoner medical parole if the parole board approves the idea that this person deserves medical parole. And that's not what happened in this case. And so that's not looking good for Zuma's lawyers. It's looking good for the other side. The second question that the court is being asked, and this is the question that we brought to the court, was whether this should have been in the prison domain in the first place in terms of seeking parole. Our argument was that Jacob Zuma was found guilty of contempt of court, which is a very special crime in South Africa. It's the only crime that you can be found guilty of, if you can even call it a crime, without a charge sheet, without the right to appeal, without many of the protections that are guaranteed for anyone who goes through a criminal trial. It's not a criminal procedure, it's a civil court procedure. And this is a technical point, but it matters because the upshot is once you're found guilty, you go to jail like a normal prisoner, but you are not under the prison boss. He's really just like a babysitter. He's taking care of.
Let me jump in here.
The prisoner remains in the custody of the court, and that makes a huge difference because it means that Zuma, if he wanted to get out, should have gone back to the court to ask permission and not gone to either the prison boss or the medical parole board. Thank you. Sorry.
Well, I was actually going to jump in there. In other words, Gabriel, the courts are in order.
It's their authority which matters most. And the reason we stepped in here is because Zuma's argument, you asked earlier, what were his lawyers saying? And the correspondent you were speaking to represented that very accurately in terms of what was going on inside of court. But outside of court, what Zuma's been saying is that he is the victim of a political conspiracy, that the very fact that he was found guilty in the first place is an indication that apartheid, this evil, racially oppressive system we had in South Africa, has been resurrected just to take him down. And specifically what he referred to is what I mentioned, that he didn't have the usual kind of criminal trial. And so he said, because he didn't have the usual kind of trial, but he was still found guilty and sent to jail, he had detention without trial. And to all South Africans, those three words, detention without trial, that sounds like apartheid. That sounds like a thing that did happen frequently as an abuse of justice. And he has been, I think, opportunistically exploiting our awful history in order to try and say the law was bad then and the law is bad today in exactly the same way, which is not true. But
well,
of course
Gabriel,
it gets him off the hook.
I'm afraid we really have to go. Thank you for your time, Gabriel Craftsman.